Any questions on the IRA trust? If not, what I want to get into is, for the next hour or so,
The next hour, I hope you have fun, Ron.
Oh, I got 30 minutes, don't I? Okay.
You gotta pick it up, Ron.
I gotta speed it up fast. All right. This says 12 questions. We'll do fewer than 12. What I want to spend the last half hour with you with is some issues on Medicaid. We touched on Medicaid a little bit for Bill and Mary's conversation, different options that we've got there. I'm going to skip a lot of this preliminary stuff, and I'm going to skip the some of the basics to kind of get you some key issues. You all kind of understand that Medicare is not going to pay for most long-term skilled care. So Medicaid winds up being the payer of last resort once you run out of money. A lot of our clients, though, they're concerned about, well, I don't want to go broke if I have to go into a nursing home. What can I do to avoid that? And there's some strategies that they can employ now to give protections against that. And we as advisors really ought to be able to know something about that. Two groups we deal with are SSI beneficiaries. They're automatically on Medicaid. But the overwhelming majority of the people we're dealing with are people that are aged, blind, and disabled with less than 300% of SSI income that permanently reside in a nursing home. That's 98% of people in nursing homes that you see. And so that's the primary key group that we deal with, and that's the rules that we generally deal with. There are income limits and asset limits to qualifying for these benefits. Mississippi's an income cap state, which means theoretically, if your income is greater than what's currently $2,163, you don't qualify for Medicaid. Now, that's a red herring, because if your income's higher than that, you can sign a little trust that says, ignore any income I've got above that. It goes to a Miller trust or a qualified income trust, and now my income is automatically below that, so I qualify. So nobody should ever not be qualified for Medicaid benefits by virtue of not having, of having too much income. If it's nursing home Medicaid, income does not keep people off. If you've got someone saying that, the caseworker doesn't understand, and we need to do something. Assets will keep you off Medicaid, though. There are asset limits, and we talked about those a little bit. There are exempt assets and non-exempt assets. We talked about a little of those this morning. The big exempt assets are the house, but again, it's up to $500,000 equity in the home, but it's going to be subject to recapture. So just because we save the house by virtue of relying on the exemption, we may lose it at death, depending on what order people die in, if there's a spouse and such involved. Current market of household goods, they're not going to go into your house and say, okay, we got to sell this couch and sell your dishes and things like that. Yes.
You can't sell the house. Let's say they go into the nursing home, they couldn't sell the house once they went into a nursing home if Medicaid was paying.
They can, yeah. They can sell it while they're alive. Now, what's going to happen is that exempt asset of house now becomes non-exempt cash, okay. And so now we're going to be spending cash. Okay. So it still takes some planning, but absolutely they can do that, and we do that frequently with clients. An automobile is exempt, and we don't put a limit on the automobile in Mississippi. Life insurance of up to $10,000. Someone already asked that question. Burial plots for yourself and your immediate family, those are exempt. Irrevocable funeral trust and prepaid funerals, those are exempt. So certainly if you got clients going into a nursing home, they need to prepay those things because it's not going to hurt them. And if they die on Medicaid doesn't allow any money going toward that. An engagement ring is an exempt asset. It doesn't mean that go to Tiffany's before you go to the nursing home. It means that if you've got an engagement ring, you get to keep it. It'll probably get stolen in the nursing home, though. So the retirement assets of a spouse are exempt under Mississippi law. That's a liberal rule that many states don't have. And the retirement assets of the applicant are exempt if they're in payout status. So you do have to have required distributions coming out. It counts as income rather than assets. Husband and wife assets are treated jointly for Medicaid purposes, and an applicant can only have $4,000 of assets, of non-exempt assets, in their own name. So it's a very low limit for a applicant. For a community spouse, that's a spouse that's the live-at-home spouse, they're entitled to keep income of up to $2,931 a month. What that really means is they keep their own income plus get to pull enough of the institutionalized spouse's income over to their own side to bring them up to $2,931. So if I got an at-home spouse that got $4,000 a month in income, and the institutionalized spouse has $2,000 a month in income, I get to keep my $4,000 because that's above $2,931. But I don't get any of my spouse's $2,000. That's all going to go to the nursing home. If, though, I'm at home and I got $1,000 a month, I got a spouse in the nursing home that's got $4,000 a month, I'm going to get to keep my $1,000 plus $1,000 $931 a month to bring me up to $2,931 is my monthly maintenance needs allowance. So that's kind of how that operates. The idea is the at-home spouse shouldn't be completely impoverished just because they had the misfortune of marrying somebody that was going to go to a nursing home. And so we're going to allow them to keep their own income plus enough of their spouses to bring them up to that minimum level. In addition to that, the community spouse is entitled to keep assets of up to $117,240. That's non-exempt assets. So we can keep the exempt assets plus non-exempt up to this $117,000 number. Anything above that, though, regardless of whose name it's in, community spouse or institutionalized spouse is going to keep them off of Medicaid. You don't qualify because we count assets joint. Okay, so what can we do about that? And some things that you need to kind of be aware of. One of the first questions I tell advisors that they need to be concerned with is you need to ask your clients, do you have powers of attorney? And you're probably already doing that. But for older clients, we ought to really be concerned about what's in those powers of attorney, because we really need what I call powerful powers of attorney. We need clauses in there that may not, in fact, usually aren't in powers of attorney most times, because we don't know what's going to happen with that older client, and if we don't know what their capacity is going to be, we may need to do things that are kind of unusual, like make very large gifts of assets out of their name to their kids or to a trust for their benefit or to their spouse or any number of things. Very, very few powers of attorney that we ever see have gifting powers, or if they do, they're limited to tax-exempt gifts. My agent can continue any gifting program that I have up to the then current annual exclusion amount, $14,000 a year. Well, that's fine if you got a rich person that's making $14,000 gifts to get their estate down. That's who that clause was designed for. But I'm not concerned about estate taxes in this circumstance. I've got an older individual that's incompetent, that can't qualify for Medicaid. He's got $400,000 in his name. But if I could get that $400,000 moved over to a spouse's name and moved over to this trust, I can qualify for Medicaid, but I don't have power to do it. He doesn't have capacity to do it. I'm stuck. So I want a power of attorney that gives me the power to, as agents, to make gifts, even if they exceed the annual exclusion amount, and even if they're to the agent themselves. So I want to waive the general rule that says the agent can't work in their own capacity, in their own self-interest, because that agent is usually the child that's going to be a beneficiary of this estate.
So if the power of attorney can change this information, can make an unlimited gift, just so that they will qualify for Medicaid. Okay, does the Medicaid clock start once they've given that gift?
Yeah.
Okay.
And so we may be disqualifying them for a while to do that, but better to start then, even if we're already in the nursing home or heading there fast, better to start it sometimes, because as we'll see in some of the strategies we get to, we can usually save half to 2/3 of the assets, even if they're already in the nursing home. So just because we're going to get penalized doesn't mean don't do it. It just means do math, And so there's plenty of good reasons to do it, even further out than the 5 years. Another thing we want to be able to do is to change beneficiaries of IRAs, 401ks, annuities, things like that. What typically happens is husband and wife, are married couple. One goes to nursing home, one stays at home. If this spouse becomes incapacitated, can't act on their own, who's going to be the beneficiary of their life insurance and their retirement account? Probably. Well, I'm probably going to be institutionalized spouse. And so this one dies, and now institutionalized spouse inherits all this money, just lost to Medicaid. We're going to lose all that money. Even if this spouse is incapacitated, I want my agent to be able to come in and change those beneficiaries so that we can make it the kids rather than have it go over here. We want to save that money. And so we want that power and the power of attorney to be able to do that. The power to create trust. One of the big strategies we'll use frequently is create a special type of Medicaid asset protection trust or even a veterans asset protection trust for protection of these assets. But very few powers of attorney give the authority of the agent to create a trust. And so we want the ability to do that even if our beneficiary is incapacitated. Healthcare documents I'm not going to go into, but make sure your clients have good healthcare documents, including HIPAA releases. Make sure they don't have I love you wills if one of them is likely to go to a nursing home. Because the worst thing in the world we're going to want is, again, this spouse is institutionalized, this spouse has a car wreck, all the assets that we protected here, the house, the $117,000 exemption, the engagement ring, now just went to my beloved spouse, which is now no longer exempt. He's got a $4,000 exemption. And so we just lost all these things during lifetime or had the house now in his name, and at death, we're going to have Medicaid take it too. So we want to change that. If we got someone heading to the nursing home, we want to do wills that probably say, I create a trust for the benefit of my spouse, but it can't be used to supplant or replace anything Medicaid's paying for. It's called a testamentary supplemental needs trust. The law allows us to create at death to protect those assets for the spouse, not disinherit them completely, but if we do it in the right way, we can protect those assets, and then they can go to the kids, not to Medicaid. Do you have a revocable trust? You have a lot of clients that'll say, I'm not worried about Medicaid, I've got all my assets in trust. Ask to see the trust, because your client, 9 times out of 10, or maybe 99 times out of 100, has a revocable living trust, and they think they've got Medicaid protection, and they don't, because that revocable trust doesn't provide any protection of assets for any kind of creditor, including Medicaid. It does a lot of good things. Again, we talked about the good things it does: probate avoidance, conservatorship avoidance, control of assets, but it doesn't provide Medicaid protection because it is a revocable trust. Do you own your home as joint tenants with rights of survivorship? Again, common way of husbands and wife owning home. If one of them's gone to a nursing home, though, we don't want that, because people don't always die in the right order. Just because this one's in the nursing home doesn't mean he's going to die first. And if the at-home spouse dies first, that joint tenancy now resulted in that house going to Medicaid eventually. So we want to change that. And so even though the house is exempt, we're concerned about the recapture in the estate, and so we want to plan against that. Yes.
What if they have a reverse? What if it's one spouse with a reverse mortgage?
That's fine. I mean, the reverse mortgage. The reverse mortgage, to the extent it's been pulled out as cash, the cash is an asset. To the extent the asset is that the cash has been spent, it's fine, as long as it hasn't been given away. Interesting question is, if I had the credit line on it, I hadn't pulled down all the money off the reverse mortgage and I had to go to nursing home, would Medicaid be able to claim that as an available asset? I don't know the answer to that. I haven't seen that issue come up. But moving the nursing home now is going to trigger their right to sell the house because you're no longer your residence. So, yes.
Are you saying that it's best not to own a home as joint tenants in ownership?
If one spouse is going to a nursing home, it's best not to own as joint tenants. Well, that's right, and that's why for older couples, I mean, that's the premise behind this is not for everybody, but for older clients, we probably need to change some of the conventional wisdom, and we may not want that house owned as joint tenants' rights to survivorship. We may want that house owned as tenants in common, as odd as that seems, because at least we protected half the house. If we got tenancy in common with both spouses creating a trust for the benefit of the other one, now one spouse dies, I still get to live in the house even if I'm not in the nursing home. I'm a beneficiary of the trust that owns half the house, and I own half the house myself. Now if I go to the nursing home, Medicaid has a claim against half the house but not against the other half. So that may be a smart thing to do at that stage. But sometimes if we kind of have an idea which ones might be likely to go to a nursing home, get his name off the trust, the deed altogether, or at least have someone with the power of attorney to be able to do it the day before we put him in the nursing home.
So the majority of people in nursing homes are females.
Yes. Yeah, overwhelming majority. That's right. They would drive the wrong spouse going to the nursing home in my example.
I'm just saying, statistically.
So, yeah. Are you really going to give these assets to your kids? That's the knee-jerk reaction of clients. They get up in age, they want to protect the house, some assets. I'm just going to give everything to my kids, start the 5 years. And there are lots and lots of lots of reasons not to do that. The kids may steal the money, they may mismanage the money and lose it. They may just be a lot stingier than you think they are. So once they got hold of the money, they're not going to give you the money like you thought they were. In addition to that, you say, well, my Junior would never do that to me. He's a good boy. Well, is it possible he might get divorced? Because you stick that in his name and he sticks it in a joint account. Now it's subject to that loss of assets in a divorce. Is it possible that Junior may die before you? It's hard to think about, but if he does, where'd that money go? Might have gone to his wife with his I love you will. If you love Junior, how do you feel about your daughter-in-law? Right. And how do you going to feel about her new spouse? Because that's where your money is. Or the two of them die together, and now it's in a conservatorship for your grandchildren, and you can never get that money back. Are there tax liens out there that you don't know about? Are there secret judgments you don't know about? Lots and lots of reasons not to give assets directly to the kids.
Have you seen most of these scenarios play out?
Yeah, unfortunately. Yeah, unfortunately we have. The better alternative, I think, than giving it directly to the kids is to give those assets into a Medicaid asset protection trust, or sometimes we call it a family wealth preservation trust. An irrevocable trust, not revocable, an irrevocable trust that it makes the asset unavailable for Medicaid purposes, that will start the 5-year clock running on it, but that you can retain a substantial amount of power over, or your client can retain a substantial amount of power over, once it's transferred. And so you kind of get to have your cake and eat it too. by doing that, we're not subject to the kid's creditor claims. We're not subject to the kid's divorce. We're not subject to the kids mismanaging, misspending the money. We can retain power over who's going to be trustee. We can retain the power to be trustee ourselves. We can retain the power to determine who the beneficiaries are. We can retain veto rights over distributions to the kids during lifetime. We can even retain the power to say who gets those assets when we die. We can retain all of those powers, but they go in trust, and yet not have it counted by Medicaid, so we start our 5-year clock running. And so usually the strategy is for clients that are starting to reach an age where they're slowing down a little bit, hitting 65, hitting 70, they're healthy enough to likely make it to 5 years, but have assets that would not be subject to, or would be subject to these claims, would be subject to be counted by Medicaid. A lot of times we talk to them about creating this type of trust, moving these assets into the trust to start the 5 years on it. Again, they've got a lot of control over those assets, even though it is an irrevocable trust. They get wrapped up sometimes with, oh, it's an irrevocable trust, I can't make changes to it. It is a flexible, irrevocable trust. They can retain lots and lots of control, lots and lots of power over this trust, and still not have it countable by Medicaid, for Medicaid purposes. The irrevocable trust that your clients are thinking about, and it's because it's the irrevocable trust that you and I have been dealing with for the last 30 years, is irrevocable for tax purposes. And if you're doing one for tax gifting purposes, yeah, you can't retain the power to make changes to the trust. You can't retain power to change who the beneficiaries are. It's not a completed gift if you do that. But for Medicaid clients, we don't care about taxes. We're not dealing with $5 million estates. We're dealing with $100,000, $200,000, $500,000, $1 million estates. And so I don't mind keeping those powers in there to keep the control where it needs to be with the parent, but let's give them the ability to feel comfortable moving those assets over to start our 5 years running. So 5 years and 1 month later, if they require nursing home care, we make application. They say, have you made any transfers in the last 60 months? No. And we're good to go, even though we've got $1 million sitting over here in trust that we've got access to if we really need it, right?
In that scenario,
Mm-hmm.
if a parent's already on Medicaid and own the house,
Mm-hmm.
If they're not in a nursing home, they're actually living in the house.
In home on Medicaid,
If
okay.
they go into a nursing home,
Mm-hmm.
then Medicaid has the claim on the house.
Yeah, if they're at home getting Medicaid and it's not the in-home care, if it's just medical, in other words, if it's not in-home care, there's a home and community-based waiver program that you receive at home that a state recapture comes into play. In nursing home care, a state recapture comes into play. If I'm just living at home and I'm getting Medicaid's paying my medical, a state recapture isn't an issue. It's an exempt asset, and Medicaid can't take the house. Okay.
But just only if they decide if you have to put them in a nursing home.
If they have to go to nursing home, now recapture just came into play.
You need to start the 5 year clock.
Yeah, I'd probably started before, but yeah,
I get you. Okay.
exactly. And there's things you can do. We can move the asset in exchange for a promissory note or something like that, reduce value. We're going to get penalized, but we can reduce our penalty, by doing some good strategies. So that's the type of trust that we want to talk to our clients about. That is an asset protection trust for Medicaid, asset protection. And it's like I said, you want to get those assets moved out of their names. Now, the issue always comes up, well, what about gifts? I've always heard you can't make gifts, right? The big myth that's out there is it's illegal to make gifts of assets for purposes of qualifying for Medicaid. Anybody heard that?
Yeah.
Not true. The rule is that if you make a transfer of assets, what we would commonly call a gift, but technically it's an uncompensated transfer. If you make an uncompensated transfer within 60 months of applying for Medicaid, there is a consequence for doing that. But that's a far cry from saying it was illegal, or saying you can't, or saying you got to give it back. That's not the truth at all. The consequence is you are ineligible for Medicaid for 1 month for every $5,700 that you've transferred. Now, if I can do the math and figure out what the penalty is, I can figure out, does it make more sense to return the asset or make more sense to keep the penalty in place? And so usually what we're able to do is make a move of the assets and incur some penalty, a reduced penalty usually, and save substantially more of the assets. And so even on a crisis basis, somebody who's already in nursing home paying privately, we can usually save half to 2/3 of the assets by doing this type of strategy. Even though we're going to disqualify them some, they're already disqualified now. They're not going to qualify for Medicaid. They spend everything and be $4,000. If I can take money and move it in a trust like this and disqualify them and get them qualified twice as fast, and at the end of the day, we've got $250,000 sitting in the bank. Now they're in the nursing home, Medicaid's paying, and I got a nest egg over here that can pay for sitters when I need it. They can pay for better meals out, for me to go to family reunions, private room, cable TV, whatever it is that helps me make me more comfortable in the nursing home, rather than that money disappearing at $7,000 a month at the private pay rate. And so you're substantially better off by making that move, even if it disqualifies you for some period of time, and even if we're going to lose half of the assets. That means we're keeping half of the assets, and so it's a much better option. It's never too late to do that, although the sooner you do it, the more money that we can save. So for advanced clients that are concerned about this for advanced planning purposes, we want to get that 5-year starter running sooner rather than later. For clients that are on closer to a crisis case basis, we're probably not going to save everything, but we want to mitigate what we can save. And so again, it may mean we want to start that clock running sooner rather than later. Okay, I got 5 minutes according to Ed. 3? All right. Let me jump ahead then. I'm missing all of my good slides, but in fact, I think I can do this. I have no idea how I got all those slides there a minute ago. There we go. That was really cool. Okay, so some of you might be interested in more about this. Okay, a couple of things that I'll make available to you. I'm a co-author on a book called Don't Go Broke in a Nursing Home. And it talks in greater detail about this and about some strategies, including some products that you can sell on an annuity basis, as well as some other life insurance policies, products that help people plan and qualify for this. If y'all want this, I didn't bring enough of them. If y'all want one of these, you can text the word ELDER, E-L-D-E-R, to the number 96000. So like if you're doing a text to somebody, text to the number 9600, and then in the message part, type in the word ELDER. That's going to send you a web form. You'll get a text message back. You'll get one message that says, "Hey, you're agreeing to let me spam you." I'm not going to spam you on text. And then you'll get another message that says, click here to fill out the form. And so you'll hit that hyperlink on your smartphone, and you'll give me your email address, your name and your email address, and that will direct you to a form that gives you the address to fill out, and I'll mail you one of these. The other thing that I'll do is send you instructions for a web app that we've designed that will let you do calculations. This may not show up on here. To help clients, yeah, here you go. You see that one that says Morton Law in the middle there below Spotify? So I'm hitting that, and there's a Medicaid asset protection calculator on there that will let you just dial in, how much assets does the person have, what's their monthly income, how much money does the at-home spouse need. Hit a calculate button, and we can get an immediate number here of, we can save $135,000 out of that $250,000 immediately. In 60 months, we'll save the whole $250,000. In 36 months, we'll start saving additional $5,700 a month. And you see that graph down at the bottom just kind of graphs out where that savings is. The green part's saved money, the red part is at risk money. There's other calculations that'll do as well, but that kind of, the conversation I had with you of we can save half on an immediate basis and stuff, that's the kind of calculation that this will do for you. And so all of you can have that app for free. If you text that ELDER 9600 to me, I will, or 96,000, I guess, 96000, I will make that available to you. And so I'll send you links of how to do that and some instructions on how to do that. And the other thing I'll do is, if you're interested in more training on the Medicaid side of thing, maybe you guys will have me back.
Yes.
Okay. Then we can do just training on that, and we'll keep you apprised of that, because I could do 3 or 4 hours just on Medicaid if that's something that y'all are interested in. So
Ron, thank you very much.
thank y'all. Appreciate it.
You can use that cup at home if you want. Since I don't text, never had.
Last year, and said in a 9-0 opinion, and these guys don't agree on a whole lot these days, but they all unanimously agreed that an inherited IRA is not a retirement account for purposes of creditor protection. And so that those beneficiaries don't get the same benefits that you or I would get for our own retirement account. It's going to be subject to creditor claims, so there's no protection. By having those assets roll into a trust for the benefit of that individual, rather than going to them directly, we can make it not subject to their creditor claims. And so we can give them protection over those assets in addition to the discipline.